The Lordship has passed an order in respect of visitation rights. From last 3 weeks, every Sunday he is going to Tapavan and waiting 1 hour or 2 hours therein, and but they are not at all coming. First 3 Sundays she came with the child. I have submitted a memo also, but thereafterwards she stopped. Every Sunday he is going there and waiting for 1 or 2 hours and coming back.
ಈಗ ಆಲ್ಟರ್ನೇಟಿವ್ ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾವು ಹಿಂಗಿದ್ದಾಗ ನಾವೇನ್ ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿ ಆ ರೀತಿ ಆರ್ಡರ್ ಮಾಡಕ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೇವೆ ನಾವು. ಈಗ ಸಿ ಪೇಮೆಂಟ್ ಬೇಕು ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಕೊಟ್ರು ಅವ್ರು. ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ಹಿ ಮೇಡ್ ದ ಪೇಮೆಂಟ್. What is that regularly paying? Huh?
No. Up to end of the August we have paid.
September ಕೊಟ್ಟಿಲ್ಲ. ಇನ್ನು ಸೆಪ್ಟೆಂಬರ್ ಅಕ್ಟೋಬರ್ನೇ ಕೊಡ್ಬೇಕಾ?
ಅಕ್ಟೋಬರ್ ಕೊಡ್ಬೇಕು.
ಸೆಪ್ಟೆಂಬರ್ ಹೆಂಗ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಇನ್ನೂ ಮುಗಿದಿಲ್ಲ ಸೆಪ್ಟೆಂಬರ್. ಆಗಸ್ಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಆಗಸ್ಟ್ ಕೊಟ್ಟಿರಾ?
ಕೊಟ್ಟಿದೆ.
ಕೊಡ್ಬೇಕಾ?
20,000 extra we have paid.
ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
ಕೊಟ್ಟಿದೆ 20,000 extra we have paid. His calculation was
ಅದು ಹೋಗ್ಲಿ, ಮಗುನ್ ಯಾಕೆ why are you holding that child for the ransack? Next time tomorrow keep for present tomorrow. Dharwad ಯಾಕೆ? A day after.
It is a case of restitution of conjugal rights. In the statement of objection, she admits that she is ready and willing to join. But now,
ಗಂಡ ಅದ್ ಬಿಡಿ. ಈಗ ದುಡ್ಡು ಏನ್ರಿ ಎಷ್ಟು ಇರಲೆವೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈಗ ದುಡ್ಡು ಕೊಡ್ತಾ ಇದಾರ ಅವ್ರು, ಕರೆಕ್ಟಾ? ಆರ್ಡರ್ ಮಾಡಿದ ಪ್ರಕಾರ 20,000 ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಾರುತ್ತೆ. ನೀವು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡಿ. ಆಲ್ರೈಟ್. ಮಗುನ್ ಯಾಕೆ ತಂದೆಗೆ ಮಗುನ್ ಯಾಕೆ ತೋರಿಸ್ತಾ ಇಲ್ಲ? ನಾಡ್ದು ಬರಕ್ ಹೇಳಿ. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಫಸ್ಟ್ ಆಫ್ parties are to be present before the court. Mother to bring the child as well. ನಾಳೆ ಶಾಲೆ ಇರುತ್ತೆ ಅದಕ್ಕೆ ನಾಡ್ದು. ಏನ್ ಕಾರವಾರ ಅಂದ್ರೆ ಏನು? ಅದೇನು ಅಲ್ಜೀರಿಯಾದಲ್ಲಿ ಇಲ್ಲೇ ಬರಕ್ ಆಯ್ತು. ಫ್ರೈಡೆ ಬರಕ್ ಹೇಳಿ. ಫ್ರೈಡೆ ಬರ್ಬೇಕು. Mother to come, appellant mother to be present before the court along with the ward. First off, absence may result into discontinuation of the maintenance order. Okay. Ha. 36 ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರಾ? ಕರಿ. Matrimony. ಅಧ್ಯಯನ ಮಾಡ್ಲಿಕ್ಕೆ ಟೆಂಪಲ್ಗಳು ಬೇಕು, ಮಠಗಳು ಬೇಕು, ಅದರಲ್ಲಿ ವಿದ್ಯಾರ್ಜನೆ ಮಾಡ್ಕೋಬೇಕು, ದಾಸೋಹಕ್ಕೆ ಬೇಕು. ಆದ್ರೆ ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಬಂದಾಗ ನಾವ್ ಅಲ್ಲಿ ಹೋಗ್ಬಾರ್ದು ಅಂತ ವಾದ ಮಾಡೋದಿದೆಯಲ್ಲ, ಅದನ್ನ ನಾವು ಒಪ್ಪಲ್ಲ. ಎನಿವೆ ನೀವ್ ಹೇಳ್ತೀವಿ, ನೀವ್ ಯಾರನ್ನ ಹೇಳ್ತೀರಿ ಅಲ್ಲಿ ಕಳ್ಸೋಣ ಅಂತ. ಒಂದ್ ಕಡೆ ಮಾತಾಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಎಷ್ಟೋ ಪ್ರಾಬ್ಲಮ್ಸ್ಗಳಿಗೆ ಕುತ್ಕೊಂಡು ಶಾಂತವಾಗಿ ಕುತ್ಕೊಂಡು ಮಾತಾಡಿಬಿಟ್ರೆ ಸೊಲ್ಯೂಷನ್ ಸಿಕ್ಬಿಡ್ತದೆ. ಎಷ್ಟೋ ಜೀವನದ ಅನೇಕ ಸಮಸ್ಯೆಗಳಿಗೆ ನಾವು ಈಗೋ ಮೇಲೆ ನಿಂತ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ. ಒಂದ್ ಸ್ವಲ್ಪ ಈಗೋ ಡೈಟಿಂಗ್ ಮಾಡಿ, ಈಗೋ ಬಿಟ್ಟು ಹಾಕಿ ನಾವೊಂದ್ ಕಡೆ ಹೋಗಿ, ಅಲ್ಲಪ್ಪ ಭಗವಂತ, ನಾವೆಲ್ಲ ನಿನ್ ಮಕ್ಕಳು, ಏನೋ ನಮಗೆ ಸಮಸ್ಯೆ ಆಗಿದೆ, ಒಂದ್ ದಾರಿ ತೋರಿಸು, ಬಂದೇವಿ ನಿನ್ನ ಹತ್ರ ಅನ್ಕೊಂಡು ನೀವು ಒಂದು ಒಳ್ಳೆ ಒಂದು ಟೆಂಪಲ್ಗೆ ಹೋಗಿ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ರಿ ದೇವರನ್ನ. ಎಲ್ಲೋ ಒಂದು ಸೊಲ್ಯೂಷನ್ ಸಿಗ್ತದೆ. ಅಲ್ಲಿ ದೇವ್ರು ಇದ್ದಾನೋ ಇಲ್ಲೋ ಈ ಜಿಜ್ಞಾಸೆ ಬಿಟ್ಟು ಹಾಕಿ ನೀವು ಲ್ಯಾಬೊರೇಟರಿಯಲ್ಲಿ ಇದರಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ. ಆದ್ರೆ ಜೀವನದಲ್ಲಿ ಕೆಲವು ನಂಬಿಕೆಗಳು ಬೇಕಾಗ್ತದೆ. DVG ಹಂಗೆ ಬರ್ದಾರೆ. ಸ್ವಾಮಿ ಜಗದಾತ್ಮಾನಂದರು ಬದುಕಲು ಕಲಿಯಿರಿ ಅನ್ಕೊಂಡು ಪುಸ್ತಕದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಎಷ್ಟೋ ರೋಗಗಳಿಗೆ ವಿಲಿಯಂ ಓಸ್ಲರ್ ಅನ್ನುವಂಥ ಒಬ್ಬ ಗ್ರೇಟ್ ಡಾಕ್ಟರ್ ಬರೀತಾನೆ, ಫೇತ್ ಹೀಲ್ಸ್ ನಾಟ್ ದ ಮೆಡಿಸಿನ್. ನಂಬಿಕೆ ಆರಾಮ್ ಮಾಡಿಬಿಡ್ತದೆ. ಅದೇ ರೀತಿ ಇದಕ್ಕೆ ಸೊಲ್ಯೂಷನ್ ಸಾಧ್ಯ ಇದೆ, ನಾವು ಹುಡುಕೊಳ್ತೇವೆ. ಮಗು ಬೇರೆ ಇದೆ, ಯು ಹ್ಯಾವ್ ಎ ಪ್ರಿಟಿ ಚೈಲ್ಡ್, ನೋಡಿ ಎಷ್ಟು ಒಳ್ಳೆ ಮಗು ಇದೆ. ಆ ಕಾರಣಕ್ಕೆ ನಿಮ್ಮಿಬ್ಬರನ್ನು ಅದು ಒಂದು ಇಬ್ಬರ ನಡುವೆ ಒಂದು ಕೊಂಡಿ ಆಗ್ಬೇಕು, ಬ್ರಿಡ್ಜ್ ಆಗ್ಬೇಕು. ಬರೀ ನಿಮ್ ಜೀವನ ಅಷ್ಟೇ ಅಲ್ಲ, ನಮ್ ಜೀವನ ಅಷ್ಟೇ ಅಲ್ಲ, ಮುಂದಿನ ಮಕ್ಳು ಇರ್ತಾರೆ ಅಲ್ವಾ, ಅವ್ರ ಬಗ್ಗೆನೂ ಮಾಡ್ಕೊಳೋದು ಬೇಡವಾ? ಬರೀ ನಮ್ದೊಂದು ಆಗ್ಬಿಟ್ರೆ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತಾ ಹಂಗಾರೆ? ಆ ರೀತಿ ಇರಲ್ಲ. ನಮ್ಗವ್ರೊಂದು ಭಗವಂತ ಒಂದು ಕೊಂಡಿ ಕೊಟ್ಟಿರ್ತಾನೆ. ಗಂಡ ಹೆಂಡತಿ ನಡುವೆ ಸ್ವಲ್ಪ ಅಟ್ರಾಕ್ಷನ್ ಕಡಿಮೆ ಆಗ್ತಾ ಆಗ್ತಾ ಹೋದಂಗೆ ಅದು ಗ್ಯಾಪ್ ತುಂಬಲಿಕ್ಕೆ ಭಗವಂತ ಮಕ್ಕಳು ಕೊಡ್ತಾನೆ ಅಂತ ಬರೀತಾನೆ. ಯಾರು ಫೇಮಸ್ ಲೆಬನೀಸ್ ಆಥರ್, ಐ ಫಾರ್ಗಾಟ್ ಹಿಸ್ ನೇಮ್, ಖಲೀಲ್ ಗಿಬ್ರಾನ್ ಸೇಸ್ ದಿಸ್. ಭಗವಂತ ಇಬ್ಬರ ನಡುವೆ ಒಂದ್ ಕಡೆ ಬದುಕಲಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಮಕ್ಕಳನ್ನು ಕೊಡ್ತಾನೆ ಅಂತ ಹೇಳ್ತಾನೆ. ಒಂದ್ ಕಡೆ ಕೂತ್ಕೊಳ್ರಿ, ಹೋಗಿ ನೀವೇ ಚೂಸ್ ಮಾಡಿ ಯಾರ ಹತ್ತಿಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಚೂಸ್ ಮಾಡಿ. ಅಂದ್ರೆ ನಾವೇನು ಡಿಸಿಷನ್ ಅವ್ರಿಗೆ ಕೊಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ನೀವು ಅಲ್ಲಿ ಒಂದು ಪ್ರಯತ್ನ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲಿ ಬನ್ನಿ, ಮುಂದೆ ನಾವು ಡಿಸೈಡ್ ಮಾಡೇ ಮಾಡ್ತೀವಿ. ನಾವು ನಮ್ಮ ಅಧಿಕಾರ ಬಿಟ್ಕೊಡ್ತಾ ಇಲ್ಲ. ಓನ್ಲಿ ಏನಪ್ಪ ಆಲ್ಟರ್ನೇಟಿವ್ ಡಿಸ್ಪ್ಯೂಟ್ ರೆಸಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ, ಆಲ್ ಏಜೆನ್ಸೀಸ್ ಕ್ಯಾನ್ ಬಿ ಎಂಪ್ಲಾಯ್ಡ್ ಬೈ ಅಸ್. ಆಲ್ ಏಜೆನ್ಸೀಸ್ ಯಾವುದು ಡಿಸ್ಪ್ಯೂಟ್ ಅನ್ನು ರಿಸಾಲ್ವ್ ಮಾಡ್ತದೆ, ಹಾಗೆ ನಿಮ್ಗಿಬ್ಬರಿಗೂ ಅನಿಸ್ತದೆ, ಅಂಥ ಏಜೆನ್ಸಿಗೆ ನಿಮ್ಮನ್ನು ಕಳಿಸುವಂಥ ಅಧಿಕಾರ, ಕರ್ತವ್ಯ ಎರಡಿದೆ ನಮಗೆ. ಬರೀ ಅಧಿಕಾರ ಅಲ್ಲ, ನಮ್ಮ ಕರ್ತವ್ಯ ಇದೆ. ನೀವಿಬ್ರು ಕೂತ್ಕೊಂಡು ಹೋಗಿ ಮಾತಾಡಿ. ಯಾರ ಜೊತೆ ಹೋಗ್ತೀರಿ ಹೇಳಿ? ನೋಡಿ, ಪಾರ್ಟಿ ಜೊತೆ ಮಾತಾಡ್ಕೊಂಡು ವಾದ ಮಾಡಬಾರ್ದು. ನೋಡೋಣ ಪಾರ್ಟಿಗಳು ಏನಂತಾರ, ಆಮೇಲೆ ನಿಮ್ಮ ವಾದ ಬಂದಾಗ ನಾವು ಕೇಳ್ತೀವಿ. ಅವ್ರು ಹೋಗಂಗಿದ್ರೆ ನಾವು ಒತ್ತಾಯ ಮಾಡ್ತೇವೆ ಅಂತ ಇಟ್ಕೋಬೇಡಿ, ನಿಮ್ಮಿಬ್ರಿಗೂ ಬಿಟ್ಟಿದ್ದು. ನೀವು ಒಂದ್ ಕಡೆ ಹೋಗ್ಕೊಂಡು ಮಾಡಂಗಿದ್ರೆ ಉಪಯೋಗ ಆಗತ್ತದ. ಆಗಿದೆ ಅದು. ನಾವ್ ಇದು ಹಂಗೆ ಹೇಳ್ತೀನಿ ತಿಳ್ಕೊಬೇಡಿ. ನಮ್ಮ ಹೊತ್ತಿಗೆ ಎಂಪಿರಿಕಲ್ ಡಾಟಾ ಇದೆ. ಈಗ ನಮಗೆ ಸಾಲ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿದ್ದನ್ನ ಎತ್ತರದ ವ್ಯಕ್ತಿಗಳು ಸಾಲ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರೊಫೆಸರ್ ಕೃಷ್ಣೇಗೌಡ ಮೈಸೂರು, ಅವ್ರಿಗೆ ಕಳಿಸಿದ್ ಸಾಲ್ವ್ ಆಗಿದೆ. ಒಬ್ಬ ಮೌಲ್ವಿಗೆ ಒಂದು ಮ್ಯಾಟರ್ ಅನ್ನು ಕಳಿಸಿದ್ವಿ, ಸಾಲ್ವ್ ಆಗಿದೆ. ಮೊನ್ನೆ ಇನ್ನೊಂದು ಕೇಸನ್ನ ನಮ್ಮ ಗವಿಸಿದ್ದೇಶ್ವರ ಸ್ವಾಮೀಜಿಯವ್ರಿಗೆ ಕಳಿಸಿದ್ದೇವೆ. ಮೋಸ್ಟ್ಲಿ ಸಾಲ್ವ್ ಆಗಂಗೆ ಕಾಣ್ತದೆ ಲಕ್ಷಣಗಳನ್ನು ನೋಡಿದ್ರೆ. ಜನ ಏನ್ರ ಮಾತಾಡ್ಲಿ, ಅದ್ರ ಬಗ್ಗೆ ತಲೆ ಕೆಡ್ಸೋಬೇಡ್ರಿ. ನಿಮ್ ಜೀವನ ಅದು. ಆ ಕಮೆಂಟ್ ಮಾಡೋರನ್ನ ಬಿಟ್ಟು ಹಾಕಿ, ಅವ್ರು ಯಾರೂ ನಿಮ್ ಹತ್ರ ಬರಲ್ಲ. ಅವ್ರು ಆರಾಮ್ ಐಷಾರಾಮಿಯಲ್ಲಿ ಕುತ್ಕೊಂಡು ಕಮೆಂಟ್ ಮಾಡುವಂಥವ್ರು. ನಿಮ್ ಜೀವನ ನೋಡ್ಕೊಳ್ಳಿ, ನಿಮ್ ಜೀವನ ನೋಡ್ಕೊಳ್ಳಿ. ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಎಲ್ಲಿ ಹೋದ್ರೆ ಸೊಲ್ಯೂಷನ್ ಸಿಗ್ತದೆ. ನಿಮ್ ಸಂಬಂಧಿಕರು ಇರ್ತಾರೆ, ಯಾರೋ ನಿಮ್ಮ ಮನೆತನದ ಗುರುಗಳು ಇರ್ತಾರೆ, ಅಥವಾ ಒಳ್ಳೆ ಟೀಚರ್ ಇರ್ತಾರೆ. ಏನೇನೋ ಕಾರಣಕ್ಕೆ ನಮ್ಗೆ ಅವ್ರ ಮೇಲೆ ನಂಬಿಕೆ ಇರ್ತದೆ. ಯಾರಾದ್ರೂ ಹೇಳಿ ಒಳ್ಳೆಯವರು, ಅಲ್ಲಿ ಹೋಗಿ ಬನ್ನಿ. ಯಾರು ಹೇಳಿ, ಒಬ್ರು ಯಾರ ಹೆಸರು ಹೇಳಿ, ಇಬ್ರು. ಹೇಳಮ್ಮ. ಮಾತಾಡ್ಬೇಕು. ಮಾತಾಡ್ದಂಗಿದ್ರೆ ನಾವೇನ್ ಬೇರೆ ನಾವ ಮಾತಾಡೋದಾಗ್ತದೆ. ಇಬ್ರಿಗೂ ನೋಡ್ರಿ, ಅವ್ರಂತಾರೆ ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ಅಲ್ಲಿ ಬರ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾ ಇದಾರ ಹೆಣ್ಣಿನ ಕಡೆಯವರು. ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ಅಗ್ರಿಕಲ್ಚರ್, ಓಕೆ, ಒಳ್ಳೇದು. ಈಗ ಯಾರ ರೀತಿಗೆ ಹೋಗ್ತೀರಿ? ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಇದೆ, ಅದು ಮೀಡಿಯೇಷನ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಇರ್ತಾರೆ, ಅಲ್ಲಿಯೂ ಪ್ರಯತ್ನ ಮಾಡ್ಬೋದು.
2-3 rounds in mediator center was tried, my lord. Whatever is suitable
for
him, whatever his preference of thing should be fine.
ಹೇಳಿ, ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಕೊಂಡು ಅಂತೀರಾ? ಆಗಲ್ಲ.
ಜಗಳ ಸಾಕಿ ಜಗಳ ನಮ್ಮ ಸುಸೈಡ್ ಮಾಡ್ತಿದ್ರಿಂದ ನಮ್ಗೆ ಧಮಕಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ನಾವು ಡೈವರ್ಸ್ ಕೇಸ್ ಹಾಕೊಳ್ಳೋದ ಇವರು 498 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ 6 ತಿಂಗಳು ಆಗಿದೆ ಮತ್ತ ಈಗ ಪ್ರೈವೇಟ್ ಕೋರ್ಟ್ ನಾವು ಕೇಸ್ ಮಾಡಿದ್ವಿ ಅದೇ ಸ್ವಲ್ಪ ಬರಲಿಲ್ಲ ಯಾನ್ ನಗರ ಹಾಕ್ಬೇಕು ವಕೀಲ ಚಲೋ ಇಲ್ಲ ನಮ್ದು ಕೇಸ್ ಬಂದಿದೆ ಅದ್ರಾಗ ಅಭ್ಯಾಸ ಇಲ್ಲ ಹಿಂಗಾಗಿದೆ ನಮ್ಗ ಇವ್ರ ಸಂಘಟ ಒಂದು ಅಣ್ಣಾಗಿಲ್ರಿ ಮತ್ ಸಾಕಾಗಿ ಇವ್ರು ಬಂದಿದ್ದು ಯಾನ್ ಮಾಡೋಕೆ ಅದೇ ಜಗಳ ಸುಸೈಡ್ ಮಾಡೋ ನಮ್ ಜೊತೆ ಏನಾಗ್ತದೆ ಯಾನ್ ಹೋಗ್ತದೆ ಅವಾಗ ಬೈತಾರೆ ಅದೇ ಜಗಳ ರೀ ದೊಡ್ಡ ಮಂದಿ ನಡುವೆ ಹಾಕಿದೀವ್ರಿ ಒಂದ್ ದಿವಸ 2 ದಿವಸ 3 ದಿವಸ ಹಂಗೆ ಮತ್ತೆ ಇದ್ರ ಮುಂದೆ ಆಯುಷ್ಯ 7 ವರ್ಷ ಆಗಿದೆ
ಹಾಗೆ ಹಾಗಾದ್ರೆ ಈಗ ಆಗಲ್ಲ ಇದನ್ನ ಯಾವ ಇಯರ್ ಇದೆ
2023.
23?
Yes.
In the third week of October, on request, suggestion for mediation having not been taken by the parties. Okay. Yes. Next.
Lord, I accept notice for both the respondents. I accept notice. Delay shall be condoned. And delay shall be condoned. 18 days delay. Instructions, my lord, by 25th they are going to release the. If he goes and communicate that they are ready to release the. In spite of a request having been made before the learned single judge, by I have instructed the officer to release, but the appellant did not visit it. But he has made an allegation again that he has, though he has visited, none of the officers have tried to release the vehicle, and now he is claiming the only ground damages. Since my lord, the second prayer in the writ petition was claiming damages against the officer.
The trial court has directed the respondent to release my vehicle. Thereafter, I have gone there, I have asked them to release my vehicle, they have not released.
Please ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅಲ್ಲ ನಾಳೆ 25ಕ್ಕೆ 25th.
ಇಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Since last 2 years, it was damaged.
ಈ ವೆಹಿಕಲ್ ತೊಳಿ ಮೊದ್ಲು, ಆಮೇಲೆ ಮುಂದೆ ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡೋಣ ಇನ್ನೊಂದು ಡೇಟಿಗೆ. ವೆಹಿಕಲ್ ಆರು ತೊಳಿ.
But the vehicle is damaged beyond repair.
ಮತ್ತೆ ಅದು ತೊಗೊಂಡು ರಿಪೇರಿ ಮಾಡಿಸ್ಕೊಂಡು ಅದನ್ನ ಇಟ್ಕೊಂಡ್ರೆ ನಾಳೆ ಅದನ್ನ ಇಟ್ಕೊಂಡು ಕ್ಲೇಮ್ ಹಾಕ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಕಾಲ್ ಆಫ್ಟರ್ 4 weeks. Next.
85. And they need to deposit before the bank because the other DRT is not organized. That's the reason.
ಸತ್ಯವತಿ ಕೇಸ್ DRT ಹೋಗಬೇಕು.
DRT has granted funds and within 6 weeks on the 2nd of October, deposit before the amount.
ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು, ಪಬ್ಲಿಕ್ ಮನಿ ಅದು.
That's deposit before this court, my same fund not have to deposit before the bank.
ಅಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
The amount is deposit.
ಆ?
The amount is deposited for this court notice.
ಇಲ್ಲಿ ಮಾಡಿದಾರ? ಯಾರು?
At the time of granting the interim order, he might deposit money.
This under court.
Single judge ಮುಂದೆ. ಅದಕ್ಕಷ್ಟೇ. My lord, one submission.
ಮಾಡಿದ್ದಾರೆ. Deposit before the court shall be transferred to his own set, adjust to the loan account of the petitioner. It's also made clear that the order will not come in the way of responding.
Transfer order ಇದೆ.
So and so ಏನ್ ತಪ್ಪಿದೆ ಇದ್ರಾಗ ಆರ್ಡರ್ ನಲ್ಲಿ? ಇದು more convenient. We would not have granted that order had we sat single.
For the DRT comes upon order to deposit of not 10,000 amount. So that amount I have to subtract that court order. That's the reason. You know, I am.
ಅಷ್ಟೇ.
I'm depositing.
ಯಾರು ರೆಸ್ಪಾಂಡ್ ಬೇರೆ ಬ್ಯಾಂಕ್ನಿಗೆ ಯಾರು ಇರ್ತಾರೆ ಹೇಳಿ? ಬ್ಯಾಂಕ್ಸ್ ಇಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ ಅಮೌಂಟ್ ಅನ್ನ ಅಲ್ಲಿ DRT ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಮಿಟ್ ಮಾಡಿದ್ರು ಅದು.
ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
ನಾಳೆಗೆ
ಡೇ ಆಫ್ಟರ್
ಪ್ಲೀಸ್.
so and so accepts notice. Here for so and so.
For 1 and 2, I accept notice.
Ah.
1 and 2, I accept.
Six of immediate control order, where not priority has to be given to the applicants who have applied for the license or repair shop. That came to be original order passed by the joint act. My society is registered.
PDS
under-
control order,
PDS
2016 order,
Yes.
92 order, ಯಾವುದು?
16.
1992 is the original order not, it is being amended 2016 and 18 also, there is some amendment.
Ah,
So my society is registered under the Soharda.
ಸೌಹಾರ್ದ.
Yes, sir. The contesting respondent, private respondent society is registered under the Cooperative Societies Act.
ಅವು ಎರಡರ ನಡುವೆ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾನ ನಾನು. ಇಟ್ ಈಸ್ ಅಫರ್ಮ್ ಬೈ ದ ಡಿವಿಷನ್ ಬೆಂಚ್. ಸೆಕ್ಷನ್ 80P ಆಫ್ ದಿ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಆಕ್ಟ್ ಕೆಳಗಡೆ ಈ ಇಶ್ಯೂ ಹೇಳ್ತು. ತೆಗಿರ ಜಜ್ಮೆಂಟ್ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ ಓದಬೇಕು ಅಂದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅದು ಒಂದು ಸಿಂಗಲ್ ಓದಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ.
That's the point what your lordship has said. That is not.
Have you brought that judgment? Bring that judgment. Pass over. Go to library and bring. The division bench has affirmed that judgment. Section 80P of Income Tax Act ನಲ್ಲಿ ಬಂದಿದೆ judgment.
Order questioning will pass the tribunal. The petitioner without filed an application for the tribunal, saying one standard increment to the minor.
Huh?
Standard increment. This contention is that endorsement is based on law state condition. Endorsement is rejected for a page number 65. A17.
Kannada increment. Kannada increment rules. ಹಾ.
They said that it is merged with the my lord revised pay scale.
ಅದು ಯಾವಾಗ ಕೊಡ್ತಾರೆ? ರೂಲ್ಸ್ ಏನಿದೆ ತೋರಿಸಿ.
But rules I have affects my lord amended rules where my lord this
ಎಲ್ಲಿ?
benefit has been withdrawn.
ಪೇಜ್
Page number my lord annexure A 17. Page number 43.
43.
Type copy. These rules may be called as another specially signed Kannada language examination community rules. They shall come into force on the date of so and so. Omission of Rule 6, Rule 6 of Karnataka. This addition was made in the year 1987.
87.
It was there much prior to that. My appointment is in the year 1981.
ನಿಮ್ಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಯಾವಾಗ ಬಂತು ಅದ್ರ ಕೆಳಗಡೆ? ಆ ರೂಲ್ಸ್ ಕೆಳಗಡೆ ವೆನ್ ಯು ಗಾಟ್ ದಿ ಎಲಿಜಿಬಿಲಿಟಿ?
I got eligibility from the date of my appointment itself. And the
ಯಾವ ರೂಲ್? ಟೆಕ್ಸ್ಟ್ ಆಫ್ ದ ರೂಲ್ ಓದಿ. ವಿಚ್ ಇಸ್ ದಟ್ ರೂಲ್?
Rule 5, which says that what affects that rules, which says that I have to make an application intimating the Milord authority saying that Milord I have not got the eligibility under Rule 5 since Milord I have passed an SSLC examination in Kannada language. It is a mandate on the part whoever passes an exam Milord they are effective for this increment.
ನೋಟಿಸ್ ತೊಳ್ಕೊಂಡು ಜಜ್ಮೆಂಟ್ ಇದೆ ಜಸ್ಟಿಸ್
I given
N.
the judgment, my lord's judgment with
ಅದಲ್ಲ ಎನ್ ವೆಂಕಟಾಚಲ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತನಕ ಹೋಗಿತ್ತು ಮ್ಯಾಟ್ರು. ILR 93, 94 ಕರ್ನಾಟಕ ಅಂತ ತೊಂಬರ್ಬೇಕು.
Reason for rejection by the tribunal, at the time of initial appointment, my lord, on her pay scale, already Kannada increment has been granted.
It was granted to.
Granted, so. Other,
ಮರ್ಜ್ ಆದ್ರೆ ಗ್ರಾಂಟೆಡ್ ಆದ್ರೆ ಮರ್ಜರು ಆಗ್ತದೆ.
so
ಸ್ಕೇಲ್ ಅನ್ನೇ
scale alle ಮಾಡ್ತಾರೆ.
that is not my problem.
Please.
ಅದು ಬರಲ್ಲ ಸ್ವಾಮಿ.
ಸ್ಕೇಲ್ ಅದು ಮರ್ಜ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಸಿಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ಯಾರ. ಜಸ್ಟಿಸ್ ಎನ್ ವೆಂಕಟಾಚಲ ಅವರು ತಮ್ಮ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ, ಅದಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ ಅವರು. ನೋಡಿ ನೋಡಿ ಶ್ರೀ ನೋಟಿಸ್ requested to accept notice. Next. Yes. ಏನು ಯಾವ ಕಾರಣಕ್ಕೆ ಮಿಸ್ಟರ್ ಕುಲಕರ್ಣಿ ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದ್ದು? Yes. ಹೇಳಿ ತೋರಿಸಿ. ಸೀರಿಯಸ್ ಆರ್ ನಾಟ್ ಇಸ್ ಅ ಮ್ಯಾಟರ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್. 54.
ಪ್ರಸ್ತುತ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಅನಾವಶ್ಯಕವಾಗಿ ಆಡಳಿತವನ್ನು ತೊಂದರೆ ಕೊಡುವುದು ಮತ್ತು ಶೈಕ್ಷಣಿಕ ವಾತಾವರಣ ಹಾಳು ಮಾಡುವುದು ಎಲ್ಲ ವಿಚಾರ ನಾನು ಹೇಳಿದ್ದು ಕೇಳಿಬಿಟ್ಟು ವೇಳೆಗೆ ಸರಿಯಾಗಿ ಕಾಲೇಜಿಗೆ ಬರದಿರುವುದು ಮತ್ತು ಕೆಲವು ವಿದ್ಯಾರ್ಥಿಗಳು ಹಿತಾಸಕ್ತಿಗಳು ಬೆಳೆಸಿಕೊಳ್ಳುವುದು, ಕಾಲೇಜಿನಲ್ಲಿ ನಡೆಯುವ ಪರೀಕ್ಷೆಗಳನ್ನು ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ವಿದ್ಯಾರ್ಥಿಗಳಿಂದ ಮೌಲ್ಯಮಾಪನ ಮಾಡಿಸುವುದು, ಕ್ರೋಢೀಕರಿತ ಅಂಕಪಟ್ಟಿ ವಿದ್ಯಾರ್ಥಿಗಳ ಕಲಿಸುವುದು, ಇದನ್ನು ಪ್ರಶ್ನಿಸಿದರೆ ಅಸಂವಿಧಾನ ಅತಿ ಉಪನ್ಯಾಸದ ನೇಮಕಾತಿಯಲ್ಲಿ ಪ್ರಭಾವ ಬೀರಲು ಪ್ರಯತ್ನಿಸುವುದು ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮವನ್ನೇ ಪೂರ್ಣಗೊಳಿಸುವುದು ಪ್ರಚಾರ ಮಾಡುವುದು, ಪ್ರಾಚಾರ್ಯ ಸಭೆಗೆ ಸಮಯಕ್ಕೆ ಸರಿಯಾಗಿ ಹಾಜರಾಗದಿರುವುದು, ಹಾಜರಾಗಲು ಸಭಾಗೃಹವನ್ನು ಪಾಲಿಸದಿರುವುದು,
ಎಲ್ಲ ಸೀರಿಯಸ್ ಇದಾವೆ. ಎಲ್ಲ ಸೀರಿಯಸ್.
Number one, my lord, as it reads, my lord, allegations upon my lord, so
ಇಲ್ಲಡಿ.
serious in suspension.
ವೇಳೆಗೆ ಸರಿಯಾಗಿ ಕಾಲೇಜಿಗೆ ಬರದೇ ಇರುವುದು ಮತ್ತು ಕೆಲವು ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಹಿತಾಸಕ್ತಿಗೆ ಬಳಸಿಕೊಳ್ಳುವುದು. We do not know.
Number two, very important thing, my lord. There is no 10-3 compliance with that. 10-3, rule 10-3 of the law of the CCA rules, my lord, contemplates, my lord, that the material, if it is placed before you, my lord, you should apply the independent and pass out the number of judgments of that.
Read 10-3.
10-3. 10-3 rules, my lord, CCA rules. In fact, on these grounds, my lord, these judgments were supplied not to us, were not submitted to the applied by the undertaken by 3-4 design judgments. Our very same tribunal dismisses it, my lord, as well as the number of matters are being allowed in that tribunal. 10-3, my lord, may I read it? Reads, my lord, the authority competent reads, my lord, the authority competent to place a government under suspension shall examine the relevant material relating to the case and consider whether there is a prima facie evidence to support the charges made against the government officer servant, and it is satisfied on such examination that prima facie evidence exists, it may place the government concerned on suspension. My understanding, my lord, report is placed.
Please read. Read the provision.
An order of suspension made or deemed to have been made under this rule shall continue to remain in force.
ಯಾವುದು ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ ನೀವು? The authority competent to place a government servant under suspension shall examine the relevant material relating to the prima facie evidence to support the charges made against
the government servant, and it is satisfied on such examination that prima facie evidence exists, it may place the government under concerned suspension. But this provision, my lord, has comes across every day almost before Karnataka Service Administrative Tribunal. Number of division judges are supported around judicial. I have produced them, they were very much here.
ಏನೋ ಒಂದು ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
These annexures were produced for not before the page 56 onwards. 56 the interim order. Then my lord, annexure A5 on 10-3 only it has been done, my lord. Then annexure A6, my lord. division bench judgment of case.
Order of suspension ತೋರಿಸಿ.
Order of suspension, there is a page 54. That's what. Page 54. ಈಗ ನಾನು ಓದಿದ್ದು what is done is ಅದನ್ನ ಆ ಕ್ಲಾಸ್ ಹಾಕೋತಾರೆ. 6 clauses ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಈ ಮೇಲೆ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ ಹೊರಡಿಸಿ ತಿರಸ್ಕರಿಸಿ ನೋಟಿಸ್ ಹೊರಡಿಸಾದ್ಮೇಲೆ ತಮಗೆ ತಕ್ಕದಲ್ಲದ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನಿಯಮವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ತರವಲ್ಲರಿಗೆ ನಡೆದುಕೊಂಡು ಕಾಲೇಜಿನ ಶೈಕ್ಷಣಿಕ ವಾತಾವರಣ ತೊಂದರೆ ಉಂಟು ಮಾಡುವ ಪ್ರಯುಕ್ತ ಬೇಕಾಗಿರುವ ಇಲಾಖಾ ಉದ್ಯೋಗವನ್ನು ಕಾಯ್ದಿರಿಸಿ where is the application of mine for him to object to this submission. Independent application should be there to show that the law really requires not suspension. Departmental inquiry charges are different. But these judgments are very much the Supreme Court. Of course, you will ask a number of lawyers might have argued. Question is, authority shall consider the mandatory.
ಯಾರು ಸಸ್ಪೆಂಡಿಂಗ್ ಅಥಾರಿಟಿ ಯಾರು?
Government. Of course, yes. These authority will not ನಿರ್ದೇಶಕರು ಶಿಕ್ಷಣ.
Government may make notes.
Director of.
There is serious complaint was made against these persons. So before making suspension him, my lord, a report was called for.
ಯಾರಿಂದ ರಿಪೋರ್ಟ್ ಬಂತು?
Not by the,
ಅದೆಲ್ಲಿದೆ ಆರ್ಡರ್ ನಲ್ಲಿ?
ಇದೆ ಅದನ್ನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. Not
ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
by the director of, by the, my lord, deputy director, my lord, did he ಹೇಳಿದ್ದಾರೆ. Not a complaint was made on that basis, my lord, before making suspension, a report was called. He visited the, my lord.
The basis of the
Yes,
report.
it is not that, my lord, simply, my lord, will not applied mind. Lord, if you see the, my lord, charges, all the charges, after the, these charges were issued, my lord, he issued a notice. He even, my lord, not issued the notice.
ಆ ರಿಪೋರ್ಟ್ ತಗೊಂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ರಿಪೋರ್ಟ್ ಯಾರು ಕೊಟ್ಟರು?
Deputy director. He visited the spot, my lord, kindly see the complaint, and all the, my lord, elected complaint was made against these persons. You can understand, my lord, if there is one person, my lord, making allegation, it can be termed as, my lord, personal. If the entire management, elected representative, made a complaint,
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ತೋರಿಸಿ ನಮಗೊಂದ್ಸರಿ.
please Thurston.
The DG is requested to accept notice for respondents. Records ತೋರಿಸಿ.
Please.
We want to look into the
Please,
records.
please.
Call on 14th. Huh?
Right now, 90 days of appeal.
90 days of?
90 days for a right from suspension.
ಅಲ್ಲ 14th ನೋಡೋಣ ಅದು. ರೆಕಾರ್ಡ್ ನೋಡ್ರಿ ಗೊತ್ತಾಗ್ಬಿಡ್ತದೆ ಏನು ಅಂತ. ನೋಡ್ಕೊಂಡು.
Bill section and can I see?
ನೋಡ್. ನೆಕ್ಸ್ಟ್. ನಿಮ್ಗೆ KET ಆರ್ಡರ್ ಇತ್ತನು ಸ್ಟೇ ಆರ್ಡರ್ ಇತ್ತಾ?
ಇಲ್ಲ, ಇಲ್ಲ.
I am just reading the.
ಅದೇ.
It's not there. Endeavor is not, probably party might have got sufficiently.
ನೋಡ್. ಕೊಡಿ. ಸರಿ. ಆಗಿದೆಯಾ? ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟಿ?
For mutual divorcement.
ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್ ಎಲ್ಲಿದ್ದಾರೆ?
I have annexed to note the copy of the joint memo along with below the history. Application that's.
ಹಾ, ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರ್ಬೇಕೋ ಬೇಡ? ಆ ಲೈವ್ ಸ್ಟ್ರೀಮ್ನಾಗ ಎಲ್ಲ ಮುಖ ಎಲ್ಲ ತೋರಿಸೋದು ಇದನ್ನೆಲ್ಲ ಮಾಡ್ತಾರೆ ಪಾರ್ಟಿಗಳದ್ದು. ಏನಾಗ್ತದೆ ನಾಳೆ ಅವ್ರು ಮಾರ್ಕೆಟ್ ಗಿರ್ಕೆಟ್ನಾಗ ಹೋದ್ರೆ? ಬೇಡವಾ? ತೆಗಿರಿ. ಹಾ.
thing. One is that Exhibit 27 and 28, which are said to be two sale deeds, and the admissibility of value,
P28.
P27 and P28, and the admissibility of value of that your lordships will attach to it. That is one.
You said
The
other day,
second,
you said cash was paid in, consideration was paid in cash. It was 25 lakh, ಏನೋ ಇತ್ತು 25 ಲಕ್ಷ ಏನೋ ಇದ್ದಂಗಿತ್ತು.
correct. Yes, and but
And
there is
small bit of
a very
plot.
small portion of land, 600 square feet or so.
600.
Square feet. But I think, there's a more compelling fact which is available to dispel that entire document. And that, my lord, is available in the records itself as Exhibit R3. And if I may only trouble my lord to kindly take the order in appeal now. This entire issue has been considered at great length by the court.
But on that basis, one clarification, on that
Yes,
basis, award was passed to which KIDB was a party, and that was rejected, meddled with by this court, coordinate bench. Matter went in SLP, and Apex Court reversed the judgment of coordinate bench. This what is
my lord,
coming
may I
out.
just explain this? My lord? How it happened was there is a particular determination made by the reference court. That was challenged, my lord, in a miscellaneous first appeal before this honorable court. When it was challenged before this court, the court set aside the award on only one ground, not on the ground of valuation. It set it aside on the ground that the CEO KIDB was not heard because he was not made a party. That question was challenged before the Supreme Court. Supreme Court said that that finding is incorrect because the beneficiary, who was ArcelorMittal, did not challenge the order of the reference court. Therefore, the judgment, my lord, of ArcelorMittal does not become today a judgment that has been affirmed by the Supreme Court or by your lordships, because your lordships have not gone into the question of correctness of the valuation at all. That, my lord, is the answer insofar as the judgment of this honorable court and the Supreme Court is concerned. This court never had that opportunity to go into it. But, my lord, interestingly, the honorable, the reference court examines this, and I would respectfully submit, my lord, quite well, in saying that I'm not bound by that order because it's not an order of a court of record. I'm only pointing this out not because there are only two ways in which it can be made applicable. Either it has to be res judicata, and therefore Section 40 of the Evidence Act will apply, a judgment in rem, which is Section 41, or a judgment under Section 42 of the Evidence Act, which is relevant but is not determinative of the facts that are contained there. If my lord kindly takes the Evidence Act for a minute.
Evidence Act.
Or my lord, I think now the
41, 44 tanka.
41 to 44, my lord. Absolutely right. 40 to 44. Would your lordship kindly look at 40, my lord, first? But 40, previous judgment relevant to a bar, that is res judicata, my lord. 40 is res
40 is
judicata.
not applicable to you.
Not applicable. Then,
No,
Lord,
one thing.
yes.
One thing. 40 parties are not same.
Parties are not same.
In
Land
that-
is not the same. So subject matter is different. Then 41, relevancy of certain judgments and probate, there is in rem orders. There is matrimonial admiralty insolvency. Then 42, my lord. 42 may have some relevance. I'll just read that to your lordships.
41
Judgment
is
or-
judgments in rem.
Yes, 41 are judgments in rem. And
So
this has
that
been
question will not.
That's not right because it's in persona. 42, judgments, orders of decrees other than those mentioned in 41 are relevant if they relate to matters of a public nature relevant to the inquiry, but such judgments, orders of decrees are not conclusive proof of that which they state. And finally, my lord, 43. Judgments, orders, or decrees other than those mentioned in 40, 41, and 42 are irrelevant unless the existence of the judgment, order, or decree is a fact and issue or is relevant under some other provisions of this act.
Where the very existence of judgment is put in issue, then you have to produce it and say judgment is there.
Exists. That's it.
That is 43 scope.
Yes, my lord. Therefore, this, in my respectful submission, at best can come either under 42 or, according to me, under 43. There seems to be one judgment on this point, my lord, which I took out. I don't think I can. I'll have it placed before my lord. Free judgment in Land Acquisition Officer versus Narayanaya considered this question and held that section 43 would apply and that these judgments 1976. No, I'm sorry, no, I just took it out. 1976, 4 SEC, page 9.
1976, 4 SEC, page
9.
They considered this aspect of the matter.
Yes, my lord. They considered specifically 43 of the Act. May I just read 2 paragraphs, if your lordship permits? I'm so sorry, my lord. I was sitting here and I did some research, and this is my. Para 25 and 26 are relevant. We find that the High Court did not consider it for some other reason. There could be no question of res judicata in such a case because an earlier
40 is excluded, no res judicata.
Yes,
subject matter different, party is different.
Not between the parties. Further, applicant was not given any opportunity to showing that the land judgment related to land which was at some distance from land whose value is so and so. Such judgments are not judgments in rem. The second point.
Therefore, 41 is excluded.
Correct. They are judgments in personam. General provision of law governing admissibility of all judgments, whether they are judgments in rem or judgments in personam, operating as res judicata, is section 43 of the Evidence Act, which reads as follows. Which my lord just now read. It is apparent that section 43 enacts that judgments other than those falling under 40 to 42 are irrelevant unless they fall under some other provision of the Evidence Act. And even if they do fall under any other provision, all that is relevant under 43 is the existence of such judgment, order, or decree, provided it is in fact an issue or is relevant under other provisions of this Act. An obvious instance of such judgment is a judgment falling under section 13 of the Evidence Act. Illustration to 13 indicates the kind of facts on which the existence of judgment may be relevant. Therefore, my lord, they did not find in favor in simply referring to an earlier judgment, which is what in my humble submission is the case with this judgment. And of course, my lord, there may be one exception. If it is a judgment of a court of record, like this Honorable Court or the Supreme Court, then the finding there may have a different impact in making a determination. But a determination of a reference court can never be have any precedential value since it is not a court of record.
No, we are not on presidential. Precedent concept relates to law
Yes.
made by the courts.
Yes.
We are not on that. We are on the evidentiary aspect of the judgment.
Correct. Therefore, my lord, my humble submission is the reference of those of what is contained there will only be applicable between those parties. Unless as a general principle, your lordships have laid down some principle which would apply across the board for all these lands. Which is why, my lord, the facts, my lord, it may happen in one particular case, the court makes a determination where sufficient evidence has not been placed on record by the respondent. But in another case, I may place evidence on record to show that the calculation that has been made in some other judgment is completely erroneous. And in this case, I'll show your lordships the finding of the reference court, which I think, my lord, will practically answer the entire argument of the other side. In this case, we produced Exhibit R3, which had the entire set of transactions which have happened from 2006 or 7 till 2011 to show the actual value of the property in this area. And that, my lord, the court has examined at great length. May I humbly request, my lords, to only look at 2 or 3 paragraphs in the reference order.
Page number?
Lord, page number 175. Para 36.
75.
175, my lord. The internal page of my appeal, I'm so sorry, of the appeal, my lord, 175, internal page 134 of the judgment. Para 36. It is pertinent to note here, Manoj, that the petitioners only produced the documents pertaining to 2010. What prevented petitioners to produce documents sale deeds prior to 2010 to show that the cost of value of land is increasing rapidly from year to year? Further, it is pertinent to note that if really the land situated at Kudithini was sold at 25 lakhs per acre in the year 2010, one of the documents P27 has been produced before the court. What prevented petitioners to produce sale deeds for the year 14, 15, 16 before the court to show that the land at Kudithini, which costs at 25 lakhs or more per acre, to disprove the said contention, RW1 has produced Exhibit R3, that is Market Value Assessment Register Extract issued by the sub-registrar, which clearly shows that during the year 2008, 10/1/2008, 2.32 acres in survey number 337 is alienated 1,62,000. On 11/2/2008, 1 acre was so alienated 80,000. 28/1/2008, 1.41 acres alienated at 85,000. On 26/2/2008, 4.98 acres alienated at 3,33,000. On 11/8/2008, survey number so and so alienated at 6,51,000. On 28/2008, lands in survey number 902 measuring 6.8 acres alienated at 6,18,000. And if you'll just come straight down to the bottom last line, because 2008-9 is there, last line 4/6/2009, the land in survey number 154 measuring 3.15 acres was alienated at rupees 2 lakh. I'm sorry, my lord's got that?
Yes.
Last line, 2,84,000. Then 13/8/2009, 2,24,000. 12/4/2009, 12.66 acres at 12,15,000. Then 2010, my lord. On 24/4/2010, land in survey number 217/4 measuring 1.5 acres alienated 1.25 lakhs. On 25/2010, land in 77 measuring 5.15 acres alienated 3,87,000. 27/5/2010, 1 acre at 2 lakhs. Said lands are all situated at Kudithini village. Likewise, on perusal of market value of land situated at Vivipura from 26/2/2008 to 27/5/2010, none of the lands were sold more than 3 lakhs. Likewise, on perusal of market value of land situated at Haragina Dhoni from 10/4/2007 to 17/3/2010, none of the lands were sold at more than 3 lakhs. Likewise, on perusal of market value of land situated at Yarangali village from 17/5/2007 to 22/4/2010, none of the lands were sold more than 3 lakhs. So perusal of documents exhibit R3 discloses that the approximate value for which the lands have been alienated in the year 8 to 10 is not more than the amount between 2 to 4 lakhs per acre. It's actually 2 to 3 million. Hence, if we compare the transaction in 2007 to 10 as per R3 and P27, there is a lot of difference in the amount of sale consideration, which is highly inconsistent. As per P27, 1 acre in survey number 670 was sold for 25 lakhs. That, of course, not is on a calculation. It is not correct to say 1 acre was sold, only 600 and odd square feet was sold. But in the same village, in the same area, none of the lands have been sold more than 3 lakhs as per Exhibit R3. So there's a lot of inconsistency in the sale consideration with respect to the sale transactions. Moreover, R3 is more probable than P27 because R3 was issued by Sub-Registrar Kurugodu. So the perusal of the said descriptions regarding the alienation of lands in the year 2008 to 10 discloses that the land were alienated for the amount of 1.5 to 3 lakhs per acre, and there is inconsistency in the value of the property. It is pertinent to note here the market value of land situated at Kudithini village, Venivura village, Yeranigondan village, Yarangali village, not having same price. It varies from area to area. Hence, without there being any evidence to prove market value of P27, P28, contents cannot be accepted as genuine because of the reason that petitioner claimants approach before the court for enhancement of compensation amount on various grounds. Then the burden is on the claimant's petitioners to prove the same before the court by placing convincing, cogent, and probable evidence before the court. I've already discussed above, except producing P27, 28, claimant did not lead evidence of either the vendor or the purchaser of P27, P28. It is also pertinent to note that when the petitioners approach the court by stating that the lands are worth more than 25 lakhs and more per acre, at least they have to produce a sketch before the court to show that the lands are situated abutting to P27, P28, or the lands are situated abutting to national or state highway or railway track situated in the vicinity of any industrial area. It is also pertinent to note here, when the petitions are very much relying on P27 enhancement of compensation, petitions have to prove before the court regarding the special features which are available in the land mentioned in P27 for its higher market value, also prove the similarities between land of the petitioners acquired by the LAO at very low rates and the lands alienated at P27 and P28. similarities in the acquired land and land shown as per 2728 for fetching lesser value and also fetching higher value of so and so. Absolutely no documentary evidence is placed by the petitioners to prove that it is 25 lakh. Then, my lord, there was another sale deed which we placed before the court. A sale deed, my lord, which was a property sold in the vicinity to as for industrial purposes. That, my lord, will find has been considered by the court at page 189, Exhibit R9. In the middle of the page, my lord, Exhibit R9. My lords have that?
Yes.
Exhibit R9 is a sale deed dated 31/2010, executed by so and so in favor of ACC Limited for a valid sale consideration of 46,20,000. On perusal of same, it reveals said amount of 46,20,000 is paid for 23.1 acres of land situated within the registration district of Bellary and sub-registration district of Bellary in Kudithini village. Further, during course of cross-examination, she admitted that the lands are acquired for the purpose of industrial factory and also admitted that at the time of acquiring the lands, they have taken into consideration the prior market value of 3 years from sub-registrar office. Further, she clearly deposed lands in so and so measuring 1 acre sold for 25 lakhs is created only for the purpose of get more compensation amount. Further denied that lands of petitioner comes from National Highway. Also denied all lands of petitioner were adjacent to main road. She clearly deposed that Exhibit 179 and other health current matters as remanded the case in the High Court. Now, my lords, have on this exemplar sale deed, my lord, which is a concept which we repeatedly speak of. The exemplar sale deeds clearly show that the total value of the land at the relevant period was only between 2 to 3 lakhs, except for these two stray sale deeds, which show consideration as having been paid in cash, which seem to have been not created for the purposes of trying to make out a case. Which is why, my lord, ultimately the court says.
Where is that apex court judgment which reversed the judgment of coordinate bench?
That I have produced it along with the memo, Your Lordship, on
Oh, filed it
17th
already?
September. I'll pass on.
In that SLO had stepped into witness box.
Please.
And the beneficiary company was not a party to this?
Beneficiary company was a party, Your Lord. Only the
Beneficiary
thing
means
is
who?
that the state was not made a
Alati.
party. Sorry,
Alati was a party.
was a party.
Now which party?
Respond number 3, my lord. Your Lordship may kindly peruse page number 1 of the judgment, my lord. From below, fifth line.
Board six. Beneficiary means allotee. Allotee is not beneficiary because in one judgment. Which other day you said beneficiary means board only, not allottees.
Please, my lord. Pirappa's judgment and Gregory's judgment, that is very clear, my lord, wherein can I demonstrate those judgment, my lord, for 2 minutes, my lord. Even there also, my lord, in Pirappa's case and Gregory's case, the specific land has been acquired for the purpose of the company, my lord, prior to the notification, my lord. There was an agreement between the KIDB as well as the company, my lord. Subsequently, my lord, the state acquires the land for the purpose of the company, my lord. And after that, my lord, there is an acquisition proceeding initiated for the specifically for the company, and then they approach the court saying that they are the interested parties, my lord. The court has
Not agree with that.
no, my lord. I have produced those judgment along with my written submissions, also along with the memo also, my lord. It is very clear, my lord.
But not the allotee. Allotee is not the beneficiary.
Board is the beneficiary.
Beneficiary.
Then it allots.
Correct.
But if it fails to implement project, again it comes back to the beneficiary.
Some other person
This logic
will not hold it.
May I make one small submission, my lord, with regard to allottees?
ಅಂತೂ ನೀವು not simple. ಅವ್ರು ಬೇಕಾದ ಇದ್ರು. ಅವ್ರು
Chapter 3 of Karnataka Area Development Regulation Board, my lord, 1969, wherein Chapter 3, Regulation 15, allottee as a licensee. May I read it, my lord? Till the agreement for lease, sale, or lease cum sale is executed, the allottee will be considered as mere licensee, who shall
He
have
will not have
license.
any concrete right at all till that event
No,
happens.
and after the award, they have got into an agreement sale, lease cum sale agreement, my lord.
But when you are allotting, will you stipulate in that allotment letter, the compensation or price which you are paying is likely to be altered in the event 18-1 or now section 74 or SLP? Is there any such stipulation, Guru? Huh? It's liable to undergo change of the condition ಇದೆಯಾ
ಅಲ್ಲಿ agreement
allotment letter ಅಲ್ಲಿ ಈಗ ನಿಮ್ಮ KIDBಗೆ ಲ್ಯಾಂಡ್ acquire ಆಯ್ತು. You are the beneficiary in the eye of law in the light of that judgment. Suppose when you allot to Mr. X, whether do you stipulate saying that the price which you are going to pay for this is likely to undergo change depending upon the outcome of 18-1 like that? Is there such a condition?
Yes, yes. It is, it is. It is, my lord. Ultimately, we have to bear the entire cost of acquisition.
It's a tentative place. So the condition of same law, any enhancement if it is there.
Will be subject.
So actually,
And my lord, now in any event, the SLAO is before the court. He is, of course, a proper party, my lord. Therefore, although I'm making submissions now.
No,
in
ಅವ್ರು
so
ಏನ್
far-
ಹೇಳ್ತಾರ ಅಂತ ನೋಡೋಣ. ಈಗ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು. Provided he argues all this, what is your argument? ಕೊಡಿ. ಆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ನಿಮ್ದೇನಿದೆ ವರ್ಷನ್?
how the judgment possibly comes to paragraph 15.
Tara? The awards and judgments.
The awards and
Manoj Kumar
judgments
case.
in cases of others not being recently are not following their course. Recently, we have seen that trend of efforts to follow them blindly, possibly at the misconception of concept of equality and fair treatment. The courts are being swayed away in this approach in the actions of and of similar nature, and situations of the land is causing both injustice and tantamount to being equal treatment. In case of commitments, as per situation of village, nature of the land, its values differ from distance to distance. 2 or 3 kilometers distance can also make a material difference in land. Land emerging highway methods nearby, but not land situated in interior villages. The previous awards judgments are only piece of evidence at par with comparative sales and sales transaction. Similarity of the land covered by the previous judgment award is required to be proved by any of the comparative example. Again, previous award judgment is based on example, which is not similar or acceptable. Previous judgment or award of the court cannot be said to be binding. Such determination has to be outrightly rejected. In case some mistake has been done in awarding compensation, it cannot be followed on the ground of clarity, and illegality cannot be perpetuated. Such awards in effect would be wholly irrelevant. There is yet another serious infirmity seen following the judgment or award passed in acquisition, made before 10 to 12 years and price is being determined on that basis by either flat increase or security increase as per the choice of individual cases, without going into the monthly finance. Such method of determining compensation is available only when there is absence of state transaction. Before issuance of notification under section 4 of the Act and for giving annual increase, evidence should reflect that price of the land had appreciated regularly and did not remain static. The recent trend for several years indicates that the price of the land is more or less static if it has not gone down. Present there is no appreciation of value. Thus, in our opinion, it is not a very safe method of determining compensation. To base determination of compensation on the previous judgment or award, evidence considering the previous judgment or award and its acceptability on judicial parameters has to be necessarily followed. Otherwise, gross injustice may be caused to any of the parties. In case some gross mistake or illegality has been committed in previous judgment and award of not making deductions, etc., sufficient evidence has not been produced, and better evidence is produced in case of claim. Previous judgment and award being not inter parties cannot be followed, and if the land is not similar in nature in all aspects, it has to be outrightly rejected, as in the case of comparative examples. Failures are at par of course for evidentiary value with such awards.
ಪ್ಯಾರಾ 19 ದಲ್ಲಿ ಕೋರ್ಟ್ ಆಗಿದ್ದು ಧ್ಯಾನ್ ಕೋರ್ಟ್ ಮಾಡಿದ ಜಜ್ಮೆಂಟ್
Yes, it's 1964 SCC 9. Yes, exactly. The judgment clause is followed. This is the judgment clause of the year 2017.
ಶಾಂತನಗೌಡ ಸಾಹೇಬ್ರದ್ದು.
To rely upon judgment award in case it does not form the part of evidence recorded by reference court. An application under Order 41 Rule 27 is to be filed to produce evidence, and if it is allowed, opposite parties to be given an opportunity to view the evidence and rebut it. The award judgment should not be taken into consideration by hearing arguments unless they form the part of evidence in the case. Therefore, the judgment notes now that has been relied upon by the other side.
ಸ್ವರ್ಣ ಸಿಂಗ್ ಕೇಸ್ನಾಗೂ ಸೇಮ್ ಮತ್ತು ಕನ್ಸಿಡರ್ ಮಾಡಿನ ಕೊಟ್ಟಾರ ಇದ್ರೊಳಗೆ ಏನು ಮಾಡ್ಯಾರ ಇದು ಮತ್ತು ನಾ ಇದನ್ನ ಓದೇನಿ ಇದು ಸ್ವರ್ಣ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಾರ ದಿಸ್ ಇಸ್ ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್. Correct, sir. In this particular case, na compilation ಮಾಡಂಗಿ ಅಥವಾ ಇದ್ರೊಳಗೂ ಇದೆಲ್ಲ ಹೇಳ್ತಾರಲ್ಲ ಬಟ್ ಸೇಮ್ ಕೊಟ್ಟಾರ. ಅದೇ ಈಗ ನನಗೆ ಇದನ್ನ ಮಾಡ್ಬೇಕು, ನನ್ನ ಹತ್ರ ಇದೆ ಅದು. ಸೇಮ್ ಹೇಳಿದ್ ಕೊಟ್ಟಾರ, ನನಗೆ ಗೊತ್ತೈತಿ 100% ಐತಿ.
ಪ್ಯಾರಾ 20 ನೋಡಲ್ ಪ್ಯಾರಾ 27 ಗುರು ಪ್ಯಾರಾ 27 They are relevant ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Para 27 ದಲ್ಲಿ see that. Neither under section 11 nor under 13.
Depend upon the evidence in the particular case in whose facts are true. Which those facts are true. The embodied findings or opinions relating to facts and issues and investigated in different cases. The existence of the judgment would not prove the value of some piece of land or help with at all in the judgment admitted in evidence. Even slightest difference in situation can sometimes cause considerable differences in value. We do not
Slowly. We do not think
necessary to take
restrictive view of the provisions of 11 and 13 as to exclude such judgments altogether from evidence, even when good grounds are made out for their admission.
judgments to be relevant if they relate to similarly situated problems and contain definitions of values.
They have followed full bench 63 judgment. Completely exclude ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ ನೀವು. That appears to be too broad a proposition. Your 76 Supreme Court is interpreted by 2017 Supreme Court. So they have referred to Bombay High Court judgments. You cannot strictly construe them.
No, which is why I'm saying, it could come under 42, which is why I said it could come under 42 as relevant, but can be shown to be wrong. Because 42 has two parts. If your lordship sees 42 speaks of relevancy, but judgment or decree not conclusive proof of what they state.
That is 41.
42.
Yeah, of course, judgments, their evidentiary material is never conclusive. Even admission is not conclusive. Section 30 or 31 is there. Evidence Act.
Correct.
Evidence Act says admissions are not conclusive evidence of what is admitted. Section says that way.
No, why I'm saying this is because if you want to take the benefit of a particular judgment, then you must also show as to how that judgment will apply to you and whether the judgment is right or wrong. So it is not simpliciter to file a judgment and say, I have filed the judgment, now give me that compensation.
No, that will not be sufficient. The factors on which the said judgment is structured, those factors need to be proved is your version.
Correct. And not
because those judgments are not taken as res judicata, nor as a precedent. They are taken only as evidentiary of what has been stated in that.
Yes, and they may only come under 11. If your lordship says section 11 of the Evidence Act, at best they'll come under 11. Not 12 and 13, because custom and right is not in question.
It's more like plea of alibi.
That's it.
This is called doctrine of plea of alibi. This is how Professor our Hiregaudra sir used to teach us plea of alibi. Section 11 used to be taught extensively in the court hall, in the classroom. Thirteen is custom.
13 is custom.
No, 13 is custom specific. Case is not that way, therefore 13 is not applicable. We can understand. But 11 plea of alibi is a big literature has been developed on that. In fact, plea of alibi, field on evidence. Field on evidence discusses extensively. Whole volume is, almost one volume is dedicated for that. All right, let us see. Just an idea, Nimdur, you are adopting arguments. Anything more to be stated?
Your lordship, in exhibit P20, my lord, wherein in the judgment of the Mittal's case, exhibit P13 is there, my lord.
P32.
13, 1-3.
31 is, here it becomes
In my case, exhibit P,
28, 7 or 28? 28.
20, my lord, sorry. Exhibit
20?
P20.
P20.
P20. And in the judgment of Mittal's case, it is exhibit P13.
Identical, same.
Please, my lord. Wherein, my lord, the last occasion I shown about this chart, my lord.
Exhibit P20 in this case.
In this case, and exhibit
becomes exhibit P31.
13, 1-3.
In,
1-3.
1-3.
Please, my lord.
In that Supreme Court
Taking into
judgment.
consideration, please, my lord. Taking into consideration of this, my lord, the market value has been fixed, my lord. But your lordship, in that particular sale transactions which has been produced by the SLAO of 2009 and 10, my lord.
Yes.
As per the case of Meherwal Kehvajia case, the highest sale deed is to be taken into consideration, my lord.
Yes.
But even assuming that if the sales statistic of 2009 and 10 of NA land is taken into consideration, the market value goes higher, my lord, which I have stated in my written submissions, my lord, as your lordship in the last
2009?
9 and 10. Written submissions. Page 7 of my written submission, my lord, I have stated with your para 18, my lord. Page 7, ink page 7.
In your written submission.
Written submission, my lord.
Page number?
7, my lord. Para 18. I have just narrated with regard to the sale deeds, my lord, that as per exhibit P20, that is compilation page number 63, the NA land rates are serial number 7 is sold for rupees 2 crore 43 lakhs 93,600 per acre, measuring 625 square meter on 7/9/2009, my lord. And that if we deduct it with the 33% towards development charges as per Ashraf's case,
That comes to 1 crore 62 lakh.
that comes to 1 crore 62 lakh 63,213 per acre, my lord. And another sale deed, which is at serial number 10, is sold for rupees 1 crore 35 lakh 30,000 per acre, measuring
But only 660 square meters there.
even my lord, as
It is of 625.
please, my lord, I have produced the judgment of the Honorable Apex Court, wherein even a small bit of land can be considered for the large chunk of land. If there is no sale deed with regard to large extent of land, can be considered with the minimum deductions, my lord. So accordingly, I have produced the judgment with regard to that, my lord. That is the Trishila Jain's case and another.
2011 Supreme Court.
Please, my lord, 2011 Supreme Court, para 828, para 82, my lord. There only 10% was deducted, 20%, my lord. And Atma Singh case, specifically this particular case, my lord, wherein agriculture land has been acquired for the purpose of industries, my lord, wherein there is an observation made by the Honorable Apex Court stating that when the land has been acquired for the industrial purpose, there will be income generated subsequently, my lord, for which para 15, my lord, may I read it, my lord? An industry established on acquired land, if runs efficiently, earn money or make profit every year. The return from the land acquired for the purpose of housing colony or offices or institution cannot even remotely be compared with the land which has been acquired for the purpose of setting up factory or industry. After all, the factory cannot be set up without the land. And if such land is given substantial return, there is no justification for making any deduction for the price exhibited by the exemplar, even if they are of small plots, my lord. And the deduction was made only 10%, my lord. And even my third judgment is Meherwal Kevajia Trust Farida Court versus State of Punjab and others, reported in 2012 5 SCC 432, my lord, para 17, my lord, wherein several exemplars with reference to similar lands. It is the general rule that the highest of exemplar, if it is satisfied that it is a bona fide transaction, has to be considered and accepted, when the land is being compulsory taken away from the person, he is entitled to the highest value, which similar land in the locality is shown to have fetched in a bona fide transaction entered into in the
Highest value should be taken
highest to be
into-
taken into consideration. And accordingly, the highest sale deed has been considered. And in Ashraf case, in this particular case, different villages arise, different areas, there were deduction of 70, 60, 30, 40, 15, 10, all different states, taking into one compilation and has deducted 33.33 towards development charges,
Which is that?
That is at page number 10, Ashraf and others versus State of
Yeah, no.
Karnataka and another reported in AR 2013 SC 3654, The land acquired in different state and in different areas, even within the different states, principles of deduction is applied to all the cases at 33.33% towards development charges, And coming to here, we are specifically relying on this particular exhibit 179, that is the judgment of the Mittal's case, Taking into consideration of these sale deeds, the SLO, wherein the deputy commissioner has directed the SLO to reconsider the document, and subsequently after taking the average sale deed of 13, the price has fixed to 50 lakh, and in the Mittal's case, the 40% has been deducted, So it comes to 30 lakh 20,270 per acre, And this particular land, as per the maps, wherein the land is particularly situated within the vicinity of industrial area, My land, though it is an agriculture land, it is having an industrial potential land, So once there is one more judgment which I have produced is with regard to the conversion of land, there are n number of judgments. Only one judgment I have produced before this honorable court for consideration is that once the land comes within the urban municipal limits, then it has to be treated as NA land, Though it is an agricultural land, but it has to be considered as NA potential, And coming to one more judgment which I have produced at page number 13, That is Nagpur Improvement Trust versus Vittal Rao, 1973, 1 SCC 500. The Constitutional Bench of Honorable Apex Court,
Very famous judgment in land acquisition.
That is very famous case,
All right.
There Article 14, which attracts, that once and moreover, in the Mittal's case, the major Kurtini land have 4,000 acres has been acquired, And Hargindoni is of 700 odd, has been acquired, They themselves admitted that there is no such sale deed beyond that, But still the land value was given to the land loser for those villagers was also of 30 lakh only, Though their land is also an agriculture land, in Mittal's case, And I have produced the judgment wherein your lordship in the last occasion has questioned that whether for the same notification, entire same notification, same rate is to be given, for which I have produced at page para 30, page 16, I have produced Ali Muhammad Beg and others was a state of Jammu and Kashmir 2017 for SCC 717, Union of India versus Balram.
Mr. Shastri pressed into service.
Sorry.
Mr. Shastri pressed into service. No?
And one more, there's Union of India versus Balram AI 2004 SC 3981, There, 13 villages acquired under the same notification for the very same purpose, Arising out of that, out of same notification, same purpose of acquisition, it was held that it would be unfair to discriminate between landowners to pay more or less to others when the purpose of acquisition is same and the lands are identical and similar, though laying in a different villages, And one more very important judgment for my particular case is, this Ali Muhammad Beg and others was state of Jammu and Kashmir and Union of India versus Harindra Pal Singh versus and others 2005 to 12 SCC 564,
Yes.
These are the judgments which I have relied, and insofar as Nandram's case also. All these are, and this particular Ali Muhammad Beg, in that particular case, SLO has awarded 3 different rates, reference court awarded 3 different rates, and the High Court has considered fixed only one rate, And though there are 3 notification of same year,
Yeah.
same amount has been fixed to the particular lands, my lord. Because the lands are of arising out of same survey, same
Ale, we'll
same
look at it.
purpose.
You have filed your written submission, na?
Yes, please.
Okay.
My lord. And practical, my lord, insofar as these technical issues with regard to my appeals, my lord, since I have filed first appeal arising out of first judgment by the reference court, my lord, I have preferred this appeal, my lord. Subsequently, after review petition, I filed one more appeal because under impression that there should be any technicalities. Since the separate award was passed, my lord, I have challenged that under this particular case. So my claimants' appeals are of 2 appeals which are pending on arising out of same LAC, my lord.
Okay.
So I have paid the court fee in 2 different portions, my lord.
Okay.
So that is to be taken into consideration.
Anything you want
And
to
my
say?
lord, one more submission. There are in 7 cases, the claimants have died, my lord. So I'm 7 cases,
Your
7
application
appeals.
is filed.
Today I have brought it, my lord, but I could not file it. It was delayed, my lord.
ಏನು ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್
Please, my lord.
ತೊಡಿ ತೊಡಿ ನಿಮ್ಮ ಅವ್ರ ಪಾರ್ಟೀಸ್ ಅಲ್ಲೂ ಇದರಲ್ಲಿ
ಇದೆ. Memo have.
ಅಲ್ದೇ ಎಲ್ಲಾರು ಸರ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಯಾವ್ದೋ ಎಲ್ಲಾರು ಸರ್ ಇವರು ಪಾರ್ಟಿ ಏನೋ ಡೆತ್ ಆಗಿದೆ ಅಂತಲ್ಲ ನಿಮ್ದ್ರಲ್ಲೂ ತರಬೇಕಾಗ್ತದೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಮೆಮೋರ್ ಹಾಕ್ಬೇಕಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಏನಾರ ಒಂದು ಹಾಕ್ಬೇಕಲ್ಲ. Then let them file application tomorrow, day after
We'll
tomorrow.
do that. We'll do that.
ಅದೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
I have, sir. Please.
ಅದ್ರ ಜೊತೆಗೆ ಮಾಡೋಣ ಆರ್ಡರ್. Day after tomorrow. Friday? Huh? You have argued, we have, don't confuse us. We have somehow.
Are not sale deeds. One is the mortgage deed, one is the gift deed, and they are not the value mentioned in the mortgage deed and the gift deed is referred to as if it's the sale deed. That's the reason why everything else is
Yes,
small
ma'am.
amount.
The document is, one is a mortgage deed for 3.5 lakhs of loan. That is taken as the value, then that is multiplied, giving a 2.5 crore value. The second one is a gift deed. In the gift deed, a value is shown.
ಎಲ್ಲಿ where have you mentioned in your reply? ಅದು at least ಮಾಡಿಕೊಡಿ ನಮಗೆ. You have to say that.
Yes, Lord. Which is why we can demonstrate that the judgment is wrong in principle.
We have produced P13 and all the enclosures that have been referred to in
Now you have seen each other's argument.
Please.
You prepare additional reply.
Please.
You prepare your statement also. Then everything needs to be updated.
Please.
Both legal and factual.
Please.
Yes, Chaitanya.
I appear in 2 connected appeals on behalf of Sri G.B. Shastri, my lord, producing the citations. My lords, in the list of authorities itself, my lords, I have stated the gist of the.
Friday.
Please.
ಇನ್ನು ಫ್ರೈಡೇನ ಕೊಟ್ಬಿಡು ತಗೊಂಡು ಮತ್ತೆ ನಮ್ಗೆ ಓದ್ಲಿಕ್ಕಾಗಲ್ಲ ಅದು ಕೊಟ್ಟು so that you can make that submission.
Please.
Great.
ಹಾ
Grateful.
ನೋಡಿ ಈಗಾಗಲ್ಲ after vacation.
Serial number 41, already connected metal was there.
40.
41. 41 which are in the lab. Connected cases stay with you. 50%.
ಜಜ್ಮೆಂಟ್ ಸಿಕ್ತಲ್ಲ
Yes, madam.
ಯಾವುದು
But Swabhimana Cooperative.
ಅದು ಗವರ್ಮೆಂಟ್ ಎಡುಕೇಟ್ ಕೊಡು.
I've given, notes. I've given the copy notes.
Lord, I'm for respondent number 5. 2 days time may be given, my lord.
For the tribunal within a period of 8 weeks, the tribunal is requested to invest the said amount, recurring fixed deposit for initial period of 1 year, automatically renewable.
ಯಾವ ಇಯರ್ 2019 ಈಗೆಲ್ಲ ಈಗ ಆಗೋದಿಲ್ಲ ಇವೆಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಒತ್ತಿಗೆ ಇದು
Notice WhatsApp version है Arshad. Parties are appointment of guardian.
Appointment of guardian is 40, serial number 40. my lords have directed me to file affidavit.
Right, ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಯಾವ್ದು ಇದರಲ್ಲಿ 43 ದಲ್ಲಿ
43 ರಲ್ಲಿ notice has to go.
ಎಮರ್ಷನ್ ನೋಟಿಸ್
43
ದಲ್ಲಿ ಎಮರ್ಷನ್ ನೋಟಿಸ್ 40 ಅಪ್ಲಿಕೇಶನ್ ಬದಲಾವಣೆ
Oh, when the next bench ನಾವೇ date fix ಮಾಡೋದು. ಅದು ಕೊಟ್ಟಿ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ ನೋಡೋಣ immediately after vacation.
May I request it tomorrow notes? Interim order I have sought notes. Interim order I have sought, but they have license if it is given to respondent number 5. Notes the financial viability has been not proved by them. Notes. Tomorrow,
All matters are posted.
interim order may be granted. Notes covered by decision of the lordships only. Notes.
ಯಾರ appear ಆಗ್ತಾರೆ?
Government advocate notes and.
What do you say? We have held that Sauvarda and cooperative are one and the same.
Yes. And that is being confirmed, notes by the division bench also. Please.